Welcome. My name is Michael Ann Peck. I work at Itasca Bank. I am a trust officer, and as Roger said, I'm also an attorney. I used to practice in estate planning and family law, and then I transitioned into this position as a trust officer with another bank, and eventually came to Itasca, so I love it. This topic is near and dear to my heart. It kind of combines two things I love, right? Estate planning and animals. So today, what I hope to give you is just an idea of, what anyone needs in an estate plan. So if you're 18, there's certain documents that you should have no matter what. A lot of people say, I don't have enough money for an estate plan. Oh, my family gets along fine. It's not going to be an issue. None of that is true. There are certain documents that every person needs in order to do a lot of things, and one of them is make things easier for your loved ones when you are gone. So I'm going to give you a little idea on, touch on those documents, and then we're going to talk about how we can use those documents to plan for our furry friends, because we don't want to leave them out, and it's kind of a newer area. In Illinois, we do recognized pet trusts, so you can set up a trust just for your pet. So it's a growing area in the estate planning field, so I think it's a great time and a great topic to be talking about today. All right, so what is an estate plan? An estate plan is something you design while you're alive, and it is your wishes for what's going to happen to your property when you passed. So an estate plan is planning for the inevitable, right? All of us are going to die. Nobody likes to talk about it. It's uncomfortable for many people. And some people feel like if I don't do an estate plan, then I'm not going to die. Well, it's really not the way it happens. So it is planning for the inevitable, something we're all going to have to face at one time or another. Why not nip it in the bud and kind of get some peace while you're alive, knowing that you've taken care of that. Because not only are you planning for the inevitable, you're going to make sure that your wishes are carried out. So you've all worked really hard in your life. You have property, and you get to say where that property goes when you pass. If you don't do that, there are certain statutes in Illinois that will take over, and that will it will direct how your property is left. So it's really important to get this estate plan in place so that everything that you've worked for is going to go to the people you want it to go to, or the charities. In addition, an estate plan is going to provide your loved ones with some stability. It's going to direct them when you're not there to direct them. A lot of times it can avoid controversy. You're going to have one child or one loved one who, said, well, mom promised me this or dad promised me this, and if you don't have it in your estate plan, a lot of times that creates a lot of controversy, and unfortunately, a lot of those types of things end up in court. And if you do your estate plan properly, the hope is it will never end up in court. And lastly, what else can your estate plan do? It can leave your legacy. So as I said before, you get to choose where the money, the property that you worked so hard for, where it's left to. So you can leave it to charities such as West Suburban, or other charities that are near and dear to your heart. You can leave your legacy in other ways. Maybe you can plan for your grandchildren's college education. If you think that would be important. So there's a lot of different ways you can leave a lasting impression on the people who are going to remain after you're gone. So an estate plan can do a lot of things. All right. So what are some of the most important parts of an estate plan? Because it kind of sounds like it's this great big plan that we have to kind of put together. And I would say that there are 3 documents that once you're 18, you should have in place. And those would be the 3 documents that I listed at the beginning. The first one is a will. The second one is a power of attorney for property. The third one is a power of attorney for health care. Again, I don't care how much money you have. I don't care if you get along great with your family and you don't think there will be a problem. These documents are very important for every person to have in place. The fourth one is a trust. A trust is a very powerful document, super helpful in many, many estate plans, but it's not something everybody needs. So this will be a theme throughout what I'm saying, which is you definitely want to talk to a seasoned estate planning attorney to help you get these documents in place. And that attorney can help you decide whether or not a trust would be a benefit to your estate plan. All right, so we've got the documents that I talked about: a will, a power of attorney for property, a power of attorney for health care, and a trust. How can we utilize these documents to make sure your pet is cared for when they're gone? So let's break them down. I'm going to talk a little bit about each document separately, and I'm going to try to integrate how we can use that particular document to plan for our pet. So the first one is a will. So simply put, a will is your direction on how you want your property distributed when you die. When you are thinking about your will and thinking about, you're going to have to think about, what property do I have? Who do I want it to go to? Who's going to be the person in charge of making sure it goes to where it's supposed to go? So these are decisions you can think about, and even before you go to an attorney, you kind of have an idea of what your answers are to these questions. So the first one is, who's going to be your executor? So the executor is going to be the person who you assign to collect all of your assets, gather them up, and then distribute them out as you outline in your will. So the executor is a pretty powerful person. You're going to want to give some thought on who should be that person. I know in a lot of families, parents, they don't want to leave any child out, and they want to, maybe could I have all 3 of my children be the executor together, because you don't want to hurt feelings or anything. I wouldn't worry about hurting feelings. Number 1, you're not going to be around. So it really doesn't matter. Number 2, assigning someone that role as an executor isn't fun. It's a difficult role. It's going to take time from their family, from their job. It's going to take about 6 to 12 months to kind of wrap up an estate generally. And so it is, and it's labor intensive. Sometimes you have to physically go to banks to close out accounts. You might have to go collect a safe deposit box. And it isn't as easy as just walking into the bank and giving them the will and saying, I'm the executor, I'm here to do what I need to do. They'll probably have to consult an attorney. So you really need to give some thought on who you think would be able to handle that role and who would take it on. Because just because you put it in your will that you want this person to be the executor, they don't have to accept. So it's also something you might want to talk to the person about and see if they would be willing to fulfill that role. You should have one executor, and you can also name a successor executor if that person, for whatever reason, can't act. So it's always good to have a backup. All right, the next people you want to think about are who should be your beneficiaries. So those are the people that are going to get your assets outright. So those are the people you're going to be gifting to, essentially. They don't have to be people. They could be organizations or friends. Those are people, obviously. So, I mean, it could be, family, friends, organizations, So there's a lot of thought to be given to who you want to choose as your beneficiaries. I know in my practice, I would have a lot of parents who their children were older and successful, and they're like, they don't need this stuff. So sometimes they skipped a generation and they would leave things to their grandchildren. Sometimes they would leave things to a needy friend or someone else who had, assisted them throughout their life. Yeah?
Can you leave them to your pets as a beneficiary?
Yes, you can. And we're getting there, but absolutely. A pet can be a beneficiary, so of a trust, not of a will. And I'll explain that in just one moment. So those are beneficiaries. And then thirdly, guardians. So if you have minor children in your will, you can name a guardian, and that would be the person who's going to take care of your children when you're not there. You cannot have a guardian in a will of a pet because a pet is actually property. Unlike a child, a pet is considered just like your car, just like your house. It's just something you own. So it is very different than a child. So you can't have a guardian for your pet, but there's other ways we get around that. So in case you wondered that. All right, so how can your will address the care of your pets? So like I just said, in Illinois, a pet is considered property. So in your will, you distribute your property. So you can distribute your pet. So you can name someone to receive your pet. That person will get the pet outright, and you will be hoping that they will take good care of your pet. And that's about all you can do with a will. So a will might be a really great way to plan for your pet if you have a very trusted person who you know loves your pet as much as you do and will follow your wishes. In your will, you can leave instructions on how to care and to manage your pet, but unfortunately there's really no way to ensure that your wishes are fulfilled. So again, a will is one vehicle that you can plan for your pet, but you will name one person or organization or entity to get that pet, and then they will basically own the pet and can do with that pet what they want. So it's similar to, like, let's say you had a summer home in Wisconsin and you left it to your 3 kids and you wanted them to each, have 3 weeks out of the summer, and then you wanted every Christmas to be spent there, and you wanted to make sure they, kept up the property, they insured it properly, and you had all these hopes and dreams for this summer home. Well, unfortunately, when you die, you leave it to them, it's deeded to them, and they can do anything they want with it. They can sell it, they can trash it. One person can buy another person out. So a pet is the exact same thing. So a will, like I said, can be utilized and might be a good tool for you to plan for your pet if you have that one person who you trust, or that organization that you trust will take care of your pet as you want. So, is the will the best tool to utilize to plan for your pet? Possibly not. Again, your will give your pet to somebody to own as their own property. Like I just said, it can be a good tool if you have that trusted person. In addition, when you leave your pet to somebody, all you've left then is the pet. And what about the expenses for the pet? Who's going to cover those? So in your will, you can also leave that person a sum of money and earmark it for, $50,000 to care for, Fido. But again, that person gets it outright. They can pick up Fido, pick up the $50,000, drop Fido off at the nearest shelter, and head to, Mexico. So unfortunately, it really has to be somebody you trust. And and believe will carry out your wishes and use the money, if you've given it to them, to care for the pet. So perhaps a will isn't the best entity to use. That's where a trust comes in. So in Illinois, we do recognize what is called a pet trust. They are actually in our statutes, and you can have a trust that is only for your pet. And as you asked me if a pet could be a beneficiary of a will, the pet would be the beneficiary of this trust. So, just like a will, when you are thinking about a trust for your pet, so a trust, let me back up a little bit. A trust is an entity that will hold the property. It will not be given outright to anybody. The property will not be given outright to anyone until the trust says it will be. The trust is set up so there's several people at play, and they can kind of watch over each other to make sure they're doing what they're supposed to be doing. So unlike a will, where the pet's just given to the beneficiary, the pet ownership stays in the trust, and a person called the trustee, so again, that's a person you're going to want to think about, who should be that person. That person is going to kind of manage the property in the trust. So the property in the trust is going to be the pet and possibly money, right? Because you're going to have money to care for the pet. So the trustee is going to be responsible to make sure the pet is being taken care of and to make sure that the money is being taken care of properly. They can invest it, try to grow it, whatever. But also, the trustee is going to distribute money out for the benefit of that pet. Who the heck is the trustee going to give it to? The caregiver. So you are going to also name a caregiver in your trust. So you're going to name a trustee. You're going to name the beneficiaries, those are going to be the animals, and you're going to name a caregiver. The caregiver is going to be the person who's actually going to house the pet, who, hopefully will provide a loving home for the pet and give it all the love that you would have given it if you were still around. The trustee and the caregiver can work very closely together. The trustee will give the caregiver money however you direct in the trust. So let's say you want the trustee to have $500 monthly for food, vet visits, daycare, bathing, whatever you want. You can put a lot of detail into a trust and direct exactly how you want your pet to be taken care of. And so that the trustee will be kind of in charge of all the property in the trust. The caregiver is the one that's actually going to be taking care of the pet, and the beneficiaries are going to be the animals. Yeah.
Because I've done a little bit of work on this already. The people that I know in trust as caregivers, they're all my age.
Yeah.
Can an organization be a caregiver?
They can.
Oh, okay.
They can. I would, like anybody, even if it was a person or an organization, I would want to check with them first and make sure they would be willing to take on that role. And that goes for a trustee, an executor, a caregiver. You're going to want to check with people, let them know you're thinking about this, and see if they would be willing to take on that role. But yeah, I know that is a problem a lot, is that, your trusted friends are your own age. Yeah, so that's, all right. So other considerations.
Michael,
Yeah.
would it also be advantageous that when you do point and you place an animal, that if it was this little Bichon and you ask someone and they say, oh, I would take that, but a couple of years later,
Yeah.
your little Bichon passes away, and now you have an English Bull Mastiff. But that individual says, oh, no, I live in a condo, I can only have a 10-pound limit. So how would you address that if that first person doesn't want it? Is that where you name other people potentially as
Sure.
successor?
Yep, in all of these roles, you should, if you can, name a successor. So if that one person, the first person, isn't able to fulfill those duties, that you've named another person who can fulfill those duties. But what you described is a really good reason to continually review your estate plan and make sure that it still makes sense for your circumstances currently. Because just as Roger said, you might have a smaller dog and that might work for this person, but if you get a larger animal, it might not work for that person. So we always recommend you review your estate plan annually, if not, if that's too much, every 2 years at least. Lots of things change, estate taxes change, your circumstances change, other people pass away and die that you maybe have named in those estate planning documents, and so you just want to make sure that they're up to date and they make sense for your current situation. So when you're talking about a pet trust, we talked about, you want to consider who your trustee is going to be and then a successor trustee. You want to consider who the caregiver is going to be. You definitely want to consider who the beneficiaries are. What are the pets that you want to be, maintained in this trust? And the more detail you can give, the better. That helps the trustee and the caregiver understand what your wishes are, and it helps them make decisions that are, what you wanted for this pet. So a trust gives you a lot of leeway. You're going to want to think about how to fund the trust, because unfortunately, if there's no money to take care of the animal, the trust is really, the animal will, what will happen is that your residuary clause in your trust, which says, if the animal kind of outlives everybody, all the caregivers and the trustee and whatnot, then you're going to have a residuary clause that says, and I just want the animal to go to XYZ. It can be a shelter, it can be another person that just gets it outright or something. But you're going to want to think about those things. What happens if the money runs out and there's no money to care for the pet? Then the trust is going to be dissolved, and the animal will have to, go however you direct it at the end of your trust. So you want to think about how to fund the trust. I think one interesting caveat in Illinois is that the funds that you leave in the trust cannot substantially exceed the amount that's going to be required to care for the pet. So a very famous case was Leona Hemsley. She left $12 million, I think, to 2 Chihuahuas. And the court, and she disinherited several grandchildren in the process. So I think the court reduced that $12 million, saying that exceeded the amount that was really necessary to care for 2 Chihuahuas. However, let's say you had a 4-year-old thoroughbred racehorse, that might live 10 more years and have, I have no idea how much it takes to take care of a horse, but I'm sure more than a Chihuahua. So maybe $12 million wouldn't be too much. So you have to balance those two and see what makes sense. So you definitely want to fund the trust with money that makes sense. And in Illinois, your heirs could go and challenge your trust and ask a judge to find that the money in the trust far exceeds what is necessary. And they could, pull back some of that money, and then it would pass as your will said it would. Yes?
Because of that, what would be the gauge that you go by determining how much?
Well, I think that you would be how much does it take to take care of your pet? What do you spend on your pet today?
I mean, she knew she wasn't gonna, that amount of money was excessive.
Right.
Well, I mean, whoever set up the trust, wouldn't they have said that to her?
And they might have.
It's gonna be challenged?
It might have. Unfortunately, It's not illegal for people to make bad decisions. And so as an attorney, I can tell you till I'm blue in the face, this isn't going to work, this is probably going to be challenged, and perhaps she wanted to do it anyway. So, yeah. Another thing you're going to want to consider is your instructions for the standard of care. You can put that in the trust. You can explain, what your expectations are. This dog gets walked 5 miles every day, and that is my expectation. It gets special food. It has to, have monthly grooming visits, whatever. You can put in a pet inspection provision. So this would be something that you direct your trustee to do. I want you to go in and check on the pet once a month, quarterly, whatever it is, to make sure that the pet is being taken care of appropriately. You could request that the caregiver provide an annual report along with a veterinary report to the trustee. So that's, a way that they can kind of balance and check one another. You can put in there that you want insurance, maybe liability insurance. If you have a dog, you don't want it to bite somebody, so you could get some liability insurance. If you have, again, I'm going back to the racehorse, but those, you can get life and health insurance on that type of an animal. So those are considerations that you want to take into account. You want to make sure the trust funds don't run out before the animal dies. So that would also probably help you in determining how much to put in there, right? Kind of gauge how long you think the animal is going to continue to live and what the annual cost is, and kind of do that analysis. You're going to want to plan for the death of the animal. So you can say if you want it buried in the cemetery, if you want it cremated, whatever you want to put those directions in that as well. And then ultimately, if the pet passes and there's money still in the trust, you're going to want to say how that money should be distributed. So the residuary beneficiaries is what we call that. So it can be a person or an organization, whatever you want. So those are definite considerations you're going to want to think about in order to make sure your document is as complete as possible. All right. In a trust, you leave money to be used specifically for the care of your pet. So the trustee will be the one, like I said, who's responsible for overseeing the care of the money, and the trustee will be the one dispersing the money to the caregiver. So again, another way they kind of check and balance one another. If the trustee is not giving the money to the caregiver will have the ability to go to court and force them to give them the money. And if the caregiver is not taking proper care of the animal, the trustee will have the ability to go to court and force them to do that or resign. So that's the nice part about a trust, is there are ways to enforce the trust to make sure that your wishes are being followed, unlike a will. So the differences between a trust and a will: with a trust, the property remains in the trust. It doesn't get distributed outright to anybody, and there's some oversight. Like I said, there are those two people who can oversee each other. The trustee has the responsibility to oversee the care of the property, which is the animal and also the money. And then the guardian or the caregiver will be the one actually takes possession and care of the pet. So in a will, unfortunately, it all just gets distributed right out to that person, and they, as I said, can do with the property what they want. Okay, so there's two documents we haven't talked about. We talked about a will, we talked about a trust. The other two documents that I have to talk about, I would be remiss if I didn't. They're called a power of attorney for property and a power of attorney for healthcare. So these two documents are very powerful. They go into effect while you're living. So once you die, these documents really have no effect. In the power of attorney for property, you appoint an agent, so a trusted person, to make financial decisions on your behalf when you are unable to. Okay? The document can be, it can go into effect immediately. So let's say you were on vacation or you were going to be out of town and you wanted someone to handle some banking needs for you, they could do that. But it can also go into effect once a physician has deemed you unable to make your own financial decisions. So you can have that document structured however you like, however you feel comfortable, but remember that whoever you're naming as your agent is going to be able to conduct your financial life as if they were you. So it has to be a very trusted person. In this power of attorney for property, you could also put instructions to that agent on how you want them to take care of your pet. Again, a pet in Illinois is property, right? And this is a power of attorney for property. So you're instructing that trusted person on how you want your pet cared for. They can spend money, to make sure they get their necessary diabetes medicine or make sure they go to their vet. So you don't want, because I've seen it happen before where people become incapacitated and the first thing that goes to the shelter is their dog, or cat. And sometimes that is, that's just horribly emotional for that person. You might be incapacitated, but you're not unable to feel love. And perhaps that was a very good companion for that person, but people don't want to have to deal with that. So if you put that in your power of attorney for property, then people know what your wishes are, that you want to remain with your pet. A power of attorney for health care, again, you're appointing an agent who's going to be a trusted individual to make healthcare decisions for you. So when you're incapacitated, that person would step in to make decisions on your behalf. This document can include your wishes regarding life-sustaining treatment. So I think a lot of people appreciate that in that document because it doesn't tell the agent what they have to do, but it says what your wishes are. And so if you've had a conversation with your agent and you say, the quality of my life is more important than the longevity, that will give that agent the power and the peace of mind to make that life-ending decision if they have to make it. Yeah.
You say that these power of attorneys are only in effect while you're living.
Mm-hmm.
Okay, well then if your pet care instructions are in that document and you die,
Right.
so does it go then to the trust? If you have it?
That exactly. That's why all these documents actually work together, right? So the powers of attorney are both in effect when you're living, and then once you pass, if you have a pet trust, then that could take over at that time. Yeah. But and I don't mean to muddy the waters, but a trust can actually go into effect while you're living, and if you've got property in there, then the trustee will take over and manage your property for you. But the property has to be in the trust. If you want a pet to be in the trust, then your attorney can drop the document that way, so that if you did become incapacitated, you would have a trust set up, and that could go into play right away, even if you're alive.
Okay, but if you leave, let's say your home
Mm-hmm.
to this person also, that they can live there, take care of the pets for their life,
Mhm.
blah, blah, blah,
Mm-hmm.
that would be
In your
a
trust.
smart thing to do.
That
too.
could absolutely be done. Yeah. Yeah.
Thank you.
All right, so I just wanted to kind of touch on how to choose a caregiver or guardian for your pet. This is a big decision and something you should really think about carefully. Obviously, it should be someone you trust, someone who you believe will take care of the pet as you would take care of the pet. You want to consider whether or not you want to compensate this person. It might be an incentive for them to do a better job, I don't know, but it's also asking them to take on a big responsibility. I would think you would maybe want it to be someone who knows your pet, who's your pet's familiar with, right? You don't want them to, not get along. You want that to be someone who understands the responsibility of owning a pet and the type of pet you have. Like Roger pointed out, if you have a friend who loves your little Chihuahua, but you want her to take care of your Mastiff, that might not be a good fit. So certainly someone who understands the responsibility of owning the pet and the type of pet that you have. Which brings me to making sure it's a good fit. You want to make sure that the person who you're asking to take on the responsibility, if your pet likes to be walked 3 times a day and this person prefers to read next to the fire most of the day, that might not be a good fit. However, if you have a dog that likes to lay by the fire all day, maybe that's a perfect fit. So you want to make sure it's going to be a good fit for both the animal and the caregiver. Another consideration is if you have two pets, do you want to appoint the same person or different people to be their caregivers? Are they a bonded pair? Do you want to make sure they stay together? Or maybe you could see them in 2 different homes, thriving with 2 different caregivers. Are there any special needs that your pet has? Do they need daily medication? Do they need to go to the vet, once a month? Do they need certain types of, activities? So you want to make sure that any of those special needs are indicated in your document, but also that the caregiver is the person who will be able to make sure that those needs are met. How will the cost for caring of the pet be taken care of? I think we touched on that a bit. So you definitely want to consider that. Another, an important or a question that you could have the trustee and the caregiver be the same person, but if you do that, then that oversight that I was talking about may not happen. But if you really, trust this person, it might make perfect sense for them to be both the trustee and the caregiver. It can be really whatever you want, which is the nice thing about a trust. It's very a unique document to you and can be drafted, the way you want it to be. An attorney is going to direct you and make recommendations, make sure that what you want in there is all legal and actually going to be fulfilled someday, but it is very personal to you and can be molded to your wishes.
Michael Ann,
Yeah.
would a bank like Itasca Bank and Trust be a trustee in a situation like this and oversee a caregiver for someone?
Absolutely. Yep, we actually have a couple pet trusts right now that we are trustee of. So yeah, a bank is a great option if you don't have that trusted person in your life. And the benefit of using a bank would be they're seasoned, they know how to do it. This is what they do day in and day out, and you will make sure it's done properly. Sometimes if an individual who's not as seasoned, things can fall through the cracks. Maybe the money isn't managed as you'd hoped and maybe ran out sooner. So having a bank as a consideration as a trustee is a good option. Yeah, I don't know about the Humane Society. Would they step into that place at all?
No, not as a trustee. We
Yeah.
don't have that capability.
Would they be a caregiver?
I can address that and
Yeah.
look them up in a minute.
Okay,
Yeah.
great.
We'll do that too if they've been,
That is good to
taking
know.
care of them for a long time.
Yeah, that's
Not all of them, but,
right.
you know.
And that's good to know. And then if that is something you are considering, if I were you, I would ask to see the document ahead of time to make sure you understand what their wishes are and that you can fulfill those. So make sure it's kind of a joint effort. Yeah, that's great. Thank you for letting us know that. So that's another great option as a pet sitter, to be a caregiver. So lastly, I will say, hopefully you've kind of gleaned that preparing these estate planning documents isn't something you should do offline, or online, I should say. You shouldn't just grab a form and fill it out and think that is a good estate plan. I highly recommend seeking the advice of a seasoned estate planning professional. And I will say that again, you don't want to go to a criminal law attorney or a personal injury attorney. You want to go to an attorney that has experience in estate planning, and specifically in planning for pets. It's a newer area, but I would there's many attorneys out there who are familiar with this and will give you the best guidance out there. The worst thing that I see happens is, someone has created their own estate planning documents and they get to my desk and, there's a provision in there that it makes it illegal, or for whatever reason we can't act, and then it ends up in court anyway. So a lot of this is done so that you don't end up in probate. I know a lot of people don't like that word. So if done properly, your estate should stay out of probate, and you won't have to worry about that. So again, another reason to use an attorney. So that is, I have a couple more questions. Yeah, go ahead.
If you drop a trust in the state of Illinois and then relocate to another state, what happens if you do the whole process?
No. So as long as the state that you drew it up in, as long as that state recognizes that as a legal document, then the state that you're living in will recognize it as a legal document as well. Yeah. So, it was our pleasure to be here. I didn't introduce my colleague, Roger Peters, so he's back there and available for questions. I'm here available for questions. And if you want any further information, our contact is on both of those handouts we gave you. We did give you a card. If you want any further information, fill it out and we'll give you a call and we can talk further. But it was really a pleasure to be here talking about such a fun topic. So thank you.
Well, thank you so much, Michael Ann. I found that informative, and I already have a pet trust, so I hope you guys did too. I just wanted to speak for a few minutes about West Suburban Humane Society and legacies. So we do have several supporters that want to give to our dogs and cats, but they are worried about end-of-life care, the rising cost of health care, and they just want to make sure they have enough for themselves throughout their life. So we do have many people who write us into their estate plan. And so I wanted to just give you an overview of what we have historically done with estate plan funds that come our way. We can't plan for these. Obviously, we never know when any of us are going to pass. So we don't write them into our budget per se to use on an annual basis, because we may or may not get a bequest in any given year. So what we have done in the past is we've created a reserve fund. In case our donations are down in any given year, we still have a fund that we can tap into and operate as normal, paying for all our vet bills and giving the high quality vet care that we do to our animals. I will tell you that came in very handy in 2008, 2009, 2010, 2011, when the economy was poor. So we definitely appreciated having those funds available. Also, this building was built mostly on bequest funds. This was a $4 million project, and roughly $3 million of the $4 million project was bequests that we had saved up over a period of about 20 years. So not everybody has to give us a huge bequest. We take anything we get, we combine it with other bequests, and last year it bought us this building. So we are very appreciative. If you have extra money in your estate plan that you are not going to use, we would love to help you preserve your legacy by helping our dogs and cats and helping our organization. I gave you our legacy brochure Page 4 talks about the various ways that you can donate money through both your estate plan, a life insurance policy, things like that. One thing I did want to address real quick, Michael Ann asked me if West Suburban Humane Society would be a caretaker. If you adopt a West Suburban Humane Society pet, we will absolutely take that pet back. In fact, it's in your contract when you adopt from us that if for some reason you cannot take care of this pet anymore and you cannot find a trusted friend to provide care for your pet, definitely have someone or bring it back here yourself. We will find another home for it. We do have people that have come to us and have said, I have this pet. They may or may not have gotten it from us. They say, I have my friend taking care of it if I pass, but if something happens to the friend, could you be the successor caregiver? And we say absolutely. We appreciate, a monetary gift that goes along with that pet just to help us pay for the cost of caring for that pet. But we absolutely would. What we would ideally like to do with any pet that we get is adopt it out by finding another forever home. So we would need to talk about, who has ownership of the pet. We wouldn't want a trust to retain ownership of the pet. We would maybe want more of a beneficiary situation where we would actually take ownership of the pet and adopt it out to another loving family. But that is definitely something that we would talk to you about. We're happy to do so. Okay, any other questions? Well, thank you guys so much for coming. We really appreciate it.